Welcome, friends of the planet. We are thrilled to have with us today one of the nation's leading experts in Supreme Court law and all things about the Supreme Court. And she's a good friend of the planet and has been one of my inspirations. She helped found her blog. It's called SCOTUS blog, and it really is what lawyers all over the country look to when they're trying to find out, what is the Supreme Court doing? What about a case? What about other lawyers who've argued cases before? It's really an incredible resource for lawyers who are doing appellate litigation. So we're thrilled to have you with us, Amy, during Women's History Month. We're featuring women all month long, and we're just thrilled that you could be with us today.
Thanks so much for inviting me. It's great to talk to you. Thanks so much for having me.
We're thrilled to have you today. And, like I said, you have worked so hard to make SCOTUS blog into this force when it comes to Supreme Court law. And we hope someday our Daily Planet will have the same kind of impact when it comes to environmental law and policy. So let's dive in, Amy, because it's a really interesting time for the court with a new
It's
Biden.
always an interesting time.
That is true.
What are you talking about?
Yes. But it's changed, let's just say. I mean, the court often is very same from year to year. Justices don't come and go very often, but we have had new justices come onto the court, particularly in the last 6 months, and that's really changed the balance of the court. And a lot of people have speculated about that in the environmental community, but we haven't really heard as much from legal experts like you. So now that the court has these 6 conservative members and the balance has changed and the personalities have changed, how do you think that will impact environmental law cases generally, which tend to be kind of scientific and heavy on facts, and administrative law, which means a lot of deference to agencies?
Sure. It's still not entirely clear. As you said, the personalities change. Justice Byron White used to have a saying that every time the Supreme Court gets a new member, it's a new court, because you've got just the 9 of them, and swapping out one personality for another creates this whole new dynamic. And as far as the effect on environmental cases, we don't know a lot specifically about how Justice Barrett might rule based on her track record as a judge on the Seventh Circuit. What we do know is that when she was nominated, she said that the judicial philosophy of the late Justice Antonin Scalia, for whom she clerked, was hers. The idea was that you hew pretty closely to the text of the statute. So, you've got that. And then you're talking about the concept of agency deference, the idea that agencies have expertise in a particular area, like the environment, and therefore are better suited than courts to interpret a gap in federal law and to interpret their own regulations. And that means that when a law is ambiguous, courts will defer to an agency's interpretation as long as it's reasonable. But when you've got a more conservative justice, somebody like Justice Barrett, somebody like a Justice Gorsuch, they may be more likely to say the law is not ambiguous. And so I think the current court, with 6 conservative justices, 6 justices who may be more inclined to read environmental statutes narrowly to, for example, to cabin the EPA's power to say that, the Clean Air Act is about air pollution, for example. It's not about climate change. It's just one example.
Yeah, those are really, I think, a top of mind for most environmental lawyers, those sorts of examples about agency deference, particularly when you see a Biden administration that might be more expansive in the way it reads these statutes. And they try to keep them more narrow, as you said. And that would be a shame, because the body of environmental law has been built up over 50 years. And then the Trump administration came in and threw a bunch of it out. So it'd be really interesting to see what they do with some of the Biden flips in some of the way these statutes have been interpreted recently. Speaking of Justice Barrett, the newest member of the court, what do you think of her latest opinion, which was about the Freedom of Information Act, so government transparency? It was a case about endangered species. The court was trying to figure out how much of the back and forth between the agency biologists and the agency that's drafting a regulation, how much of that back and forth should be out in the public. What do you think about her initial opinion? It's interesting because she brought over Justice Kagan on side with her. Do you think that it will have a big impact on transparency in general and sort of these fact-based cases, again, that tend to be the typical environmental case tends to have a lot of facts in it?
From a Supreme Court nerd standpoint, rather than the environmental law standpoint, everybody really focused on it because it was her first majority decision. There's a tradition that a justice's first decision is unanimous frequently, as Justice Kagan's actually wasn't, but many of them are. And this wasn't a unanimous decision. And so we're all trying to sort of read the tea leaves to see what's going on. It may well be that just perhaps there weren't any unanimous decisions in November, and so they couldn't find one to give her. And then the other sort of Supreme Court gossip was that Justice Breyer dissented and apparently forgot to use the word respectfully when he dissented. He had 2 dissents that day, and one of them said, with respect, I dissent. But then his dissent in the FOIA case did not use that phrase. He added it later on.
Interesting gossip.
Exactly. This is what we do all day.
Forget Harry and Meghan.
Exactly. As a reporter who's not sort of steeped in environmental law, you read Justice Barrett's opinion and it's very well written. She's a good writer and it's very clear. And you think, yeah, no, it's interesting. And then I read Justice Breyer's dissent, and I've been reading a lot of Justice Breyer lately because of the possibility, the speculation that he might retire soon, to give President Biden an opportunity to step down. And one of the things about Justice Breyer is that he is a pragmatist. He's a liberal, but he's a pragmatist. He really got into he wrote how the process actually works. And so what he said is that, they call it a draft opinion, biological opinion, finding that an agency proposal is going to put endangered species in jeopardy is essentially a final opinion. That actually was really interesting to me. And then, as you said, the other question in my mind was sort of, where was Justice Kagan in all this? Was this something where she sort of went along with the Barrett opinion, to try it because it was a first opinion, give it sort of a sheen of bipartisanship?
She too is an expert on administrative
She too is
law.
an expert. It was a really interesting case for me.
Usually when the 2 agencies writing the opinion agree, then they send it over in that draft form in order to help the agency writing the regulation, because these are opinions about what an agency's regulation will do to an endangered species. Usually you send it over so there's a little room for back and forth to be able to craft something that's workable for the action agency, not to put them in a bad spot with the regulated community. So it's a really interesting case. It may force the agencies to be more hard in their biological opinions, which will then hurt the agencies writing the regulations, and in fact may even make it more difficult for the people being regulated. So it'll be interesting to see how it plays out. And those biological opinions take years to write. So there's been a lot of back and forth already before you get to the final draft. An awful lot, a lot of science goes into them. So I think it's a tough case for a court, especially the Supreme Court, to hear. How does the Supreme Court actually get involved in some of these cases? And it seems like there are more and more, like this one that's been repeating itself for decades now, between 2 states, the state of Georgia, my home state, and the state of Florida, over water rights. So tell us about these original jurisdiction cases.
So original jurisdiction cases are cases that start directly in the Supreme Court. There is no trial in a federal district court. There's no appeal to some intermediate court. This is something that comes from the Constitution, which gives the Supreme Court original jurisdiction over cases affecting ambassadors, public ministers, and consuls, and those in which a state shall be a party. And part of this was that, back when the Constitution was drafted, we didn't have this well-developed court system. Congress then, in the Judiciary Act of 1789, gave the Supreme Court original jurisdiction over cases between 2 states. And the idea was that the Supreme Court would be the impartial forum for states to resolve their disputes, because essentially the states didn't trust each other to resolve the disputes for Georgia to resolve the dispute between Georgia and Florida, or vice versa.
Right. And judges in federal courts in those states come from those states, so they might be biased in one way or the other for their home state.
One thing to keep in mind these days is that just because Florida goes to the Supreme Court and says, I want to file a lawsuit against Georgia in the Supreme Court, doesn't mean that you automatically get to keep your lawsuit there. You have to ask permission, and the Supreme Court has to grant your request. And we saw that at the end of last year when Texas tried to file an original case case in the Supreme Court to block Pennsylvania and the other battleground states from casting electoral college votes for Biden. There's a lot of water rights cases that wind up in the Supreme Court.
Yeah, and I think there'll be more and more. The court has reheard this case. They keep sending it back to a special master, someone who can help them find the facts. Because in a Supreme Court argument, they don't have time to sort of find all the evidence, the factual background, the basis for actually interpreting the law, right?
Right. I mean, they don't have time. And even if they did have time, they still wouldn't want to do it.
They wouldn't want to do it. They worked this hard to get to the top. So
let's pay someone else to do it.
Yeah.
Let's outsource this.
But it's funny because those special masters also can kind of take sides. And each time this case has been heard, it seems like the special master has come out somewhat differently and leading the court to even more confusion over what to do between Georgia and Florida. And in this last hearing, they were grasping at straws when it came to equities and the equities of the case, but they didn't really understand how the equities fit in the environmental law context. And I just wonder what you thought about that. Did the opinion read as awkwardly to you as it did to me as an environmental lawyer?
It did. I mean, and on the one hand, the special master, just to sort of walk through the process in a little bit more detail to give a sense of what's going on. So they hired a special master, they appointed a special master. The special master held a trial, and then the special master writes a report. And almost all of the time, somebody doesn't like the special master's recommendation. So they go back to the Supreme Court. The Supreme Court heard oral argument a couple of years ago, ruled for Georgia. Then it comes back and appointed another special master. The current iteration of the case in the Supreme Court is about what the second special master did with the evidence of the facts, how he balanced the benefits to Florida, the harm to Georgia that would come from limiting Georgia's water use. And at one point, the Chief Justice just kind of threw up his hands and said, trying to assess who's responsible for the oyster industry's collapse is like being the detective on the murder on the Orient Express. You've got all these different moving parts. There's this beautifully written friend of the court brief by Lisa Blatt, who's a lawyer who argues at the Supreme Court regularly on behalf of local seafood workers that describes that, in the first person, the collapse of the oyster industry in 2012 that kind of points up the problem with the fact that these cases take so long to litigate, and said, that the effect has been devastating. And if we don't get a steady supply of fresh water from the river, the oysters aren't going to recover.
And it's not just the oysters. That's the thing. It was really sad to me that the case was so limited, again, by what comes to the court. What really is hurt is the entire ecosystem, which means the seagrass is gone, which means the fish are going to go. It's not just oysters, it's all the recreational fishing. That whole part of Florida is at risk now. And if you look south of that, the ecosystem's pretty much collapsed on the Gulf side of Florida. And you've seen red tides that close the entire coast of Florida for a year and a half. And people, if you don't go there, you don't realize that there's a much bigger question here at work about that water needing to be there to keep the system, the blood pumping literally through the system in Florida and Georgia. Meanwhile, you have Atlanta, where I'm from, where there's just millions of people who need water to drink. So
right.
These are hard cases. There isn't an easy answer.
Right. And Justice Barrett actually raised a question at oral argument. She said, basically, how do we go about deciding these cases? Like, is it just a cost benefit analysis? Or is there something more than that? Like, how do you put a price on this stuff?
Yeah, it was really interesting because they really sort of fell back on that in the end. Who's got more financial interest? And again, this is where the law is not really great at quantifying the benefits, the ecosystem benefits. We're getting better at it, and Justice Barrett might remember the oil spill in the Gulf, where we quantified the losses based on how much oil was spilled. Anyway, we could go on and on. These climate change cases are not going away. This case in particular is driven by climate change, and it keeps coming back because there's less and less water because of climate change. So that brings me to my last question, which is, what do you make of all the climate change litigation, all the kids who are trying to get to the Supreme Court, and cities and municipalities and local leaders who feel like they've been just let down and stuck with this huge problem of climate change, and they're trying to litigate their way to the court to get to some of the responsible parties. What do you think about those cases? Are they going to make it?
Yeah, so the court has already kind of tiptoed around the edge of some of these issues. A couple of years ago, the Juliana climate change lawsuit came to the court sort of on an emergency appeal, and the court told the federal government it wasn't going to block the lawsuit. The court said there's substantial differences of opinion about whether the claims belong in the court, but we're not going to stop it. And then the court heard oral argument in January in climate change lawsuit brought by Baltimore against
Yes.
all the major oil companies. And the question is a very procedural one. I went back and looked at the story that I wrote, and climate change really didn't even come up that much. This was about the company's efforts to transfer the case from state court to federal court. But these cases are going to continue to come to the Supreme Court on, I think I would probably get in trouble with my kids if they heard me say this, like climate change adjacent issues. But inevitably, the bigger, more on point climate change questions are going to come to the Supreme Court. With the sort of conservative core on the court, my just sort of off the cuff guess is that there are probably 6 justices who are going to be skeptical in terms of reading the statutes on which the plaintiffs rely, or on federal statutes or on the Constitution, to try and find a right to bring these lawsuits. But, we'll see.
We'll see. These issues are going to be very familiar, I think, to judges all over the country. And as a result, they're going to make it to the Supreme Court, and we'll see what happens. The politics of climate are changing too, and it won't be quite as obvious that these cases will fall out along the lines of Republican appointed justices versus Democratic ones. But we'll see.
Yeah, we'll see. I mean, that is definitely true. I mean, I think we saw, with same-sex marriage, how quickly just sort of the way that people thought about it changed, leading to the Supreme Court's decision.
I think the more things become believed by a broad swath of the public, which climate change is starting to be something that most Americans really think is happening, I think that will hopefully give the court a little bit of a more perspective on these issues. But we'll see. Thank you so much, Amy. It's been a real pleasure to have you with us today, and we will keep reading SCOTUS blog. I recommend it to all of my friends and all of our readers. If you want to know anything that's happening at the Supreme Court, SCOTUS blog is your go-to. So thanks, Amy, and we'll see you soon.
Great to talk to you. Thanks so much for having me.